I'm Spencer Mazyck, and joining me now is Eric Lasker. He's a partner at Hollingsworth who, along with his team, recently obtained a significant victory on behalf of his client, military contractor DynCorp International, in a mass tort case alleging widespread environmental damages and personal injuries in northern Ecuador. Welcome, Eric. Thank you for joining us today.
Thank you for having me, Spencer.
So, Eric, the claims in this case stem from your client's aerial herbicide spraying operations in southern Colombia as part of an initiative called Plan Colombia. So first, can you tell us what was the plan?
Sure, and just to be clear, the spraying operations were conducted by the Colombian National Police with the assistance of the United States Department of State. And my client was a contractor for the State Department. And if you remember back in the 1990s, the late 1990s, Colombia was becoming a failed state because of the cocaine industry. Cocaine traffickers had control of most of the large swaths of the country. And Plan Colombia attacked the coca trafficking in that country. It's been an amazing success over the past 10 years. Coca cultivation has dropped by over 50%, and cocaine shipments into the United States have dropped dramatically. And DynCorp has been a major part of that effort.
As part of the plan, DynCorp allegedly sprayed herbicide almost daily from January to February 2001, according to the plaintiffs, and they claim that this resulted in what?
Well, the plaintiffs' allegations were that the spraying of the coca crop, which was growing in the border of Colombia, that our spraying operations on the border were drifting into northern Ecuador and causing impacts in that country. Now, that claim had been investigated by the State Department, by the United States EPA, the United States Department of Agriculture, and also an expert team from the Organization of American States, and there was no scientific basis for it, but there were a lot of individuals in that part of Ecuador who were alleging that that's what was taking place.
But they were saying that there was severe health problems, there was significant damage to the crops, is that right?
Well, that's what they were alleging, but the rulings we just recently received from the district court confirmed our position and the position of every independent group that's looked at this, which is that there were no such impacts.
Well, and I want to get to the rulings in just a second, but the case began back in September 2001. Can you tell us who the plaintiffs are, just to be clear?
Sure. We have two groups of plaintiffs, and they've changed over the course of the litigation, but at its height, we had three provincial governments in Ecuador at the border who were bringing what are called parens patriae claims on behalf of their citizens for property damage and for lost tax revenues and other allegations along those lines. And they brought a claim that they valued, or their expert valued, at about $500 million. We got that claim thrown out on standing grounds back in 2010. Basically because the claims were derivative of the individual claims, and also foreign governments don't have that right to sue in the United States. And that left the second group of plaintiffs, which again at its height was 3,300 individuals at the border area in Ecuador who were claiming that they had had those impacts on their farms and on their crops and on their persons.
And was it a strategic decision on your part to fight these claims here in the U.S. instead of seeking to dismiss them based on forum nonconvenience?
Sure, that's one of the first decisions we had to make in the case. And there are a number of advantages to filing a motion for forum nonconvenience. It's a pretty common approach when you have claims that arise from actions overseas where all the conduct and injury is alleged to have taken place overseas. The problem with that is if you move for dismissal on forum nonconvenience grounds, you have to agree to personal jurisdiction in that alternative forum, in this case, Ecuador. And we were concerned that the judicial system in Ecuador would not be fair for our client, would not provide the types of defenses that we knew or we were confident would prevail. In the United States courts, you can't come into and bring a case based upon junk science. If you don't have reliable scientific evidence to support your claims, you can't get to a jury. We also had a very strong government contractor's defense. So we thought we were in a much better position in the United States courts, and so we decided not to file the forum nonconvenience motion.
And at the same time that this case began, as you know, Chevron faced similar mass tort claims by the same plaintiffs or similar plaintiffs, and it is now trying to avoid enforcement of a $19 billion judgment rendered against it by an Ecuadorian court. Do you think that it would be in a different position today if it had left the case here in the U.S.?
Well, let me first state it was Texaco at the time, and I think certainly looking back on the decision, it's easy to second guess. They had a number of good reasons for the decision that they made. They had a release that they had executed with the Ecuadorian government that they would not be sued for their operations in Ecuador because they had cleaned up all those operations. And there were a number of other reasons for their decision. I'm not going to second guess that, but obviously we're happy with where we ended up.
And in March, the U.S. District Court unsealed 2 opinions that were rendered in February. But before we get to them, can you tell us why were the court documents sealed in this case?
All of the documents relating to this operation are the custody of the United States Department of State. Again, this is a United States State Department program. DynCorp does not have possession of any of the documents, and so the confidentiality order in the case was based upon the State Department's position.
The first opinion was a summary judgment in favor of your client on claims related to livestock and crops. Can you tell us what was the court's rationale for that ruling?
Sure. The plaintiff's claim from the beginning rested largely on the personal eyewitness accounts. And they were alleging that they could proceed with their crop and animal damages claims based solely on their own eyewitness testimony, and they argued they had hundreds and thousands of individuals who were making these claims. My partner, Rosemary Stewart, went down to Ecuador and she deposed 20 of the plaintiffs, and she was able to demonstrate that their stories really didn't hold together. They kept changing their stories. They were not reliable. She also spearheaded our effort for personal questionnaires that we had all the plaintiffs file, and we got 1,200 of the plaintiffs thrown out just on those grounds because they couldn't support their allegations. And so the plaintiffs' attempt to rely solely on their own eyewitness testimony, I think, was undercut from the beginning. And the court correctly recognized that plaintiffs need to have expert testimony. They need to present scientific evidence to support their claims, and they were not able to do so. And that was the basis for the court's ruling that those claims couldn't go forward.
And that brings us to actually the second opinion, which I think was released about a week or so after the first. And in that, the court granted your motion to exclude testimony from the plaintiff's sole expert witness, Dr. Michael Wilson, regarding the human health claims. So can you tell us why did the court grant your motion here?
Sure. The issue under U.S. law is whether or not Dr. Wilson could present any reliable and relevant science in support of his opinions. And I took his deposition for 2 days, and we went through in great detail his opinions. And again, he was unable to present any reliable scientific basis for his opinions. He could not testify that any of the plaintiffs were exposed or what level of exposure they had. He couldn't testify at what level of exposure he believed the herbicide, which is glyphosate. It's a very safe herbicide. It has no health effects of any significance. He couldn't allege how much would be needed to cause these effects. And in fact, he was relying very heavily on studies of people who tried to commit suicide. They would take a cup of Roundup, they'd pour it into a cup, and they'd drink it down. Even then, most of them didn't die. So he didn't really have any sound scientific basis for his opinions. And that's what the court decided when he reviewed all that testimony, that the opinions that the doctor was providing and was going to testify to court were just scientifically unfounded. They had no basis, and therefore they were not admissible in court. And once the court decided that there was no reliable science in support of the plaintiff's claims, that's why the court granted summary judgment to us. And it was vindicating everything we had been saying throughout the case.
And so you don't view this win as based on a technicality, but you do view it as based on the merits of the case.
Oh, it's definitely on the merits of the case. I mean, the ruling of the court confirms what we've been saying all along, what the U.S. government and the Colombian government and the expert panel of the Organization of American States said all the time, which is that there is no adverse health effects from these spraying operations. They're very safe spraying operations. The only thing that they're not safe for is coca. They kill the coca. They've destroyed the coca crop in Colombia, and that's had a huge positive impact both on depriving terrorist organizations who are being funded by those crops and in keeping cocaine from coming into the United States. It's been a big success.
Does this decision speak to some international activists who try to demonize U.S. companies in their international operations?
I think that's certainly part of what was going on in this case, and I think they often pick improper defendants, and their arguments are very strained. In this case, I'll say that I've been extraordinarily proud to be representing the people of DynCorp International. They are amazingly committed people. They do a very dangerous job. At one point, we looked at the statistics, and there were more pilots who were shot down over Colombia than there were shot down over Iraq or Afghanistan in the recent wars there. It's a dangerous job. It's an important job. They do it well. And I'm very gratified that we were able to come up with a favorable result for them.
So tell me, how did you come to represent the military contractor DynCorp International?
We got the work through a referral, and then we had a interview process. Hollingsworth LLP has a long history in representing government contractors and in handling the types of mass torts and scientific evidence that were central to this case. We've had a lot of success in defending these types of cases, and that's the best way of getting business. You win your cases, and other people find out about it. That's what happened here, and that's how we got the business.
Well, thanks so much for joining us today. We really appreciate it.
Thank you. It's been a pleasure.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.